Hello, my name is Andrea Adams, and today I'll be presenting on special education services in school. Okay, so we are going to go through some of the special education laws from the birth of special education in the United States up until more present day cases. Okay, so the first act we're going to talk about is the Education for All Handicapped Children Act of 1975. And this act, also known as EAHCA, was considered the birth of special education in the United States. That's why I chose the picture of the student who has the puzzle piece, and special education is that puzzle piece. So hopefully that will help children benefit more from the education that's offered. And it was enacted to ensure that children with special needs are receiving and benefiting from a public school education. Okay, so we don't typically hear EAHCA anymore, and that's because the act has been amended a few times. So in 1990, EAHCA was amended to IDEA, or Individuals with Disabilities Education Act, which is something most of us have heard before, and it was amended even one more time in 2004 to the Individuals with Disabilities Education Improvement Act, IDEIA. Okay, so the first case that covers EAHCA, or the Education for All Handicapped Children Act, that we're going to talk about is Rowley v. Hendrick Hudson School District of 1982. The Rowley case was the first Supreme Court interpretation of Education for All Handicapped Children Act. So, because it was the first Supreme Court case that had to interpret EAHCA, Rowley is now the standard interpretation for subsequent cases. So if a case comes up today, it's not uncommon for them to look back to the Rowley case. So the Rowley case centered around Amy Rowley, who had limited hearing, but she had become an excellent lip reader. And she was very intelligent, and she was actually performing above the class average without an interpreter. But typically, you would expect that if a student had very limited hearing, that they would be allowed an interpreter, right? That would be considered a free and appropriate education. But some people said no, because she's actually performing above the class average without an interpreter. So I'm going to pose a question to you. What services do you think that she is entitled to? Okay, so we will talk more about that as we move on. Okay, so child find. Child find is an ongoing process seeking children eligible for services from birth to age 3 and from age 3 to 21. And it requires public schools to seek out children who are eligible for services in their jurisdiction who are not currently receiving a public school education. This also came from when EAHCA was enacted, because the government realized that there were a bunch of students, 8 million students about, in the United States who are not receiving special needs services. And that's why this child find was put in place, to make sure that they receive those services. Okay, so as we move on, the 3 big federal statutes of special education that we're going to reference include IDEIA, Individuals with Disabilities Education Improvement Act, which is the amended version of EAHCA that we've been talking about. The second federal statute is the Americans with Disabilities Act, or ADA, of 1990, and the third federal statute that we'll talk a lot about is the Rehabilitation Act, Section 504 of 1973. In the text by Essex on page 97, there's a quote that I pulled, and it says, "These statutes were enacted to protect individuals with disabilities from discrimination and provide them equal access to educational opportunities, facility utilization, and employment opportunities in public school settings." So hopefully the combination of these 3, you would think, would bring students a more just and discrimination-free access to public education.
Did you know that the F in FAPE stands for Free Appropriate Public Education? That means all education and related services you and your child's team determine are necessary to address his needs must be provided at no cost to you. This may include things like curriculum and materials, related services like OT, PT, and speech, assistive technology, building modifications, transportation, one-on-one aids, and more. A solid individualized education program, or IEP, is the key to ensuring that your child receives a free...
Okay, the next case that we're going to talk about that is under free and appropriate education is Timothy v. Rochester case of 1989. Timothy v. Rochester was about how a school cannot deprive a child with a FAPE based on the premise that the school believed the child would not benefit from the education. So basically what happened was Timothy was a severely mentally handicapped child, and the school had been interpreting EAHCA to mean that a student with a FAPE of special education services, that a student is not necessarily entitled to special education services if they would not benefit from them academically. Timothy's parents obviously argued that all children should be entitled to a free and appropriate education, right, appropriate to that individual student. So a student should not just be classified based on, they should not be judged based on their classification. Every education needs to be individualized to the individual. And so what's free and appropriate for one student might not necessarily be appropriate for another student with a mental handicap. So in this case, the court ruled that obviously just because a student may not on paper benefit from the special education services that the school had to offer, that he or she should not necessarily not still receive an education, because that is something that they're entitled to under the federal statute. It did actually turn out, though, that a lot of schools had been interpreting EAHCA this way, so that if students weren't quote-unquote benefiting from the academic services of the special education departments in their district, the schools weren't giving them out, and this drew a lot of attention to that. And for that reason, Timothy versus Rochester is something that a lot of cases will refer to if a school tries to take away services, because it proves legally that every child is entitled to services if they require them. Cedar Rapids versus Garrett F. of 1990 is another case that falls under FAPE, under IDEA or IDEIA, and it helped determine what qualifies as quote-unquote related services under that act. And it includes medical services as long as it is not one usually administered by a physician. Okay, so what happened in this case is that Garrett, who was a very intelligent boy, he had a motorcycle accident when he was very young, and it left him paralyzed and ventilator dependent. So he required catheterization and ventilator monitoring because his ventilator was life-sustaining. So when the parents sued after the motorcycle accident, they received money, and they had been using that money to help pay for Garrett's education when he was very young. So eventually, in elementary school, the parents wanted the school to try to take over those medical costs because I'm sure that they were a huge burden. So what actually happened is that because there was a case before this, I believe it was Tatro, that case said that if the service required a doctor, which ventilator monitoring could technically require a doctor to do since it was life-sustaining, that the school shouldn't be responsible for it because of the burden that it would cause. But in this case, under IDEIA or IDEA, the school is required for round-the-clock nursing services when the child's at school, because the child requires that in order to receive a free and appropriate education. Because if he didn't have his ventilator monitored, obviously he couldn't learn. But he was of average intelligence, so there's no reason why he should be kept from the general education setting. Okay, so another act that we said was one of the big three federal statutes was the Americans with Disabilities Act, or ADA, of 1990. Okay, in this act it says that no qualified person shall, by reason of such disability, be excluded from participation or be denied the benefits of services, programs, or activities of a public entity or be subjected to discrimination. Okay, so the main goals of this act were to prohibit discrimination and ensure equal opportunity for those with disabilities. Okay, it works hand in hand with Section 504 of the Rehabilitation Act, which we'll be talking about in a minute. Okay, in the Rehabilitation Act, Section 504 of 1973, there's a broader definition of disability than IDEA because it protects more people. It was originally created for veterans by a president, and it prohibits discrimination against an individual with disabilities in programs and activities receiving federal funding. So any program that receives federal funding has to follow Section 504. So it promotes access to activities with reasonable accommodations, including extracurricular activities. So this is not just within the school. This is for the grocery store that received some sort of federal funding to open. This is for the town hall activities that receive federal funding. This includes extracurricular activities, which is excellent for people, both students in school and for companies and for anyone who could potentially have members with disabilities. This is wonderful. Okay, so it includes anyone whose impairment quote-unquote substantially limits one or more basic life activities. And by this, we have to ask ourselves, what is considered to substantially limit one or more basic life activities? So Section 504, when they said major life activities, they meant things like caring for oneself, walking, standing, lifting, performing manual tasks, seeing, hearing,